there are groups called heir finders. They identify heirs at law that can inherit, and then they send them a letter, say, hey, we'll get you your inheritance, you just give us 15%.
The court found that he had to give that family member half of the money that he was going to make. And he said this person never knew him. How do they even, I didn't even know we had family over there.
You can actually quickly draft a will.
Yeah.
Without even witnesses, actually. But it has to be all in your own handwriting. It's what's called a holographic will. You may be able to buy out the tenants, but you can't really terminate their tenant rights, and at least not easily, unless they're not paying the rent.
Okay, so thank you for joining me, Tom.
Thank you.
Can you please tell us a little bit about yourself and how you started this business?
Sure. Well, I've been an attorney since 1996, and I first got into probate law and estates when I did my first probate. I had done an estate plan for an individual who died unexpectedly. And so I probated his estate for his mother, and that's when I first came across probate law. And it's an area that I very much enjoy. I also do estate planning, which is planning for your legacy, protecting your assets, protecting your legacy and your wealth for future generations.
Got it. And you mainly work in California or a specific city, or which cities or counties do you work in?
All of the Bay Area.
Okay.
And I have done probates as far south as LA County and some rural counties in California, but primarily my practice is in San Francisco, San Mateo, Alameda, Marin, Santa Clara.
Okay.
So
thank you. So you said you started in 1996, right?
That's right.
Okay. And was your intention to go into this profession, like this field, or were you looking into a different type of law?
When I first started, I did whatever came in the door because I hung my shingle out when I was quite young, and was a solo practitioner. I'm still a solo although I have a lot of people on my team now. But I did everything from landlord-tenant law to some personal injury to contract disputes. And I even started estate planning back then. So I've had a lot of experience with that.
So you started by yourself under someone? You started your own practice?
Well, I did work for some big firms for a couple of years.
Okay.
I really hung out my shingle later.
Yeah.
After getting some experience.
Yeah.
That's always worthwhile to do, getting experience after law school. But I pretty much hung out my shingle pretty early on.
Yeah. That reminds me of me and my real estate profession. I started off pretty aggressively, like I'm going to do this on my own, and then worked under someone, and then quickly got into all types of real estate and realized probate and trust is my
Your
area.
niche.
Yeah.
That's great.
Awesome.
So we've actually worked on a few transactions together, and and it's been really a pleasure to work with you on those.
Likewise. And the reason why I wanted to talk to you is because San Francisco tends to be a little bit more challenging sometimes, and we'll go over that when it comes to tenants or reverse mortgages or the tenant laws that happen here.
Or HOAs.
Or HOAs that we've dealt with. HOAs and some challenges that can come up, especially when you're going through probate. So I know your expertise is essential, especially for properties that we worked on here in San Francisco. So when we talk about estate planning, as you know, my emphasis is probate and trust real estate. So a lot of my clients need estate planning, have estate planning, or are going through probate. And they're going through very challenging circumstances. What are some comprehensive must-have documents for an estate plan? Or can you tell us a little bit about that?
Sure. So anyone who owns real estate needs to have a trust. Anyone in California specifically needs to have a trust. Otherwise, that property is going to have to go through probate, at least in the Bay Area. That's still accurate. There was a recent change to the law that may affect probates in more rural counties where the real estate market is less expensive. Okay, but in the Bay Area, you need a trust, and that usually comes along with ancillary documents, including a pour-over will that places assets within the trust that are not initially transferred into the trust. You need powers of attorney from financial affairs and also medical power of attorney. A HIPAA authorization. There's a few other documents that I would also include in that. A memorandum of transfer of personal property. That's a kind of a supplemental document to the trust where you can add things of, let's say, a collection, or you want a specific, let's say you want your tea set to go to your Aunt Millie or something like that. You can actually itemize that in this without having to change or restate your trust. We also provide a end of life burial or cremation wishes and memorial service wishes. That's helpful for those that you leave behind.
Absolutely.
So there's a variety of documents that are included in an estate plan, but the essential ones are really the living trust, the powers of attorney, and also when you're dealing with real estate, it's very important that you have a trust transfer deed, which is actually placing that real property into the trust.
Yes.
Because if you don't do that, then it's not actually a trust asset.
Right.
And it may require further court procedure, like a Hexted petition is one specifically, where you actually have to get a court order to place it into the trust, and you have to convince the court that that was your intention.
Right.
So to avoid all that, you need to fund your trust.
And I find that people, we've talked about this before, believe if they have a will, they're set. And that's going to keep them out of probate court.
No, that's not true.
Yeah.
In California, wills have to be proven before the court to be carried out, at least when you're dealing with assets over a certain threshold. And that threshold currently is $184,500 for personal property and $750,000 when you're dealing with real property. So I alluded to this earlier, when you're dealing with rural counties, you may be able to use a less formal procedure to transfer an asset.
Right.
It has to be a primary residence. It has to be under $750,000. And like I said, in the Bay Area, most properties are not going to qualify for that procedure. So your will would need to be probated to transfer your property. That less formal procedure is called a small estate affidavit. And that's maybe a topic for another conversation.
Yeah.
So a will is not sufficient. That has to be proven in court, and it goes through the probate process, which is expensive. It is very time consuming. There's a lot of hurdles that you have to jump through, and it can take anywhere from between a year to a year and a half, and if there's some squabbling amongst the heirs, it can take 2-3 years. I mean, it's something you want to avoid if you can. And the way you avoid it is by having a solid estate plan, having a trust in place, and also reviewing it every few years.
Right.
Or if there's a major change in life circumstances, such as you have a new child, or maybe one of your children has a very debilitating disease or accident where they need a special needs trust. So major change in life circumstances, maybe a divorce, you need to update your estate plan.
Yeah. I actually sold a property in which the couple got divorced and they forgot to remove the wife. So when we sold the property, his family was so upset because they had to, she actually was a person who was the beneficiary. I don't know if that's a proper term, but when he passed away, the house would go to her immediately.
So that sounds like a joint tenancy.
Exactly. It was a joint tenancy situation. She was nice enough to give the family half of what she made, the profit that she made, which the house had already been paid off. But the family was so upset because she was able to keep the funds, and she had been divorced for 20 years.
Wow.
They just forgot to update everything.
Yeah. So that could have happened because the family law attorney didn't, tie up loose ends at the end of the
Yeah.
divorce process. I see that a lot, actually.
Right.
No offense to the family law practitioners out there, but I find that they don't handle these issues,
Yeah.
changing how title is held. Yes, there's maybe a mediated settlement agreement as to what to do with the marital property, but they don't actually change the title on the
Right.
deed. So that's exactly the circumstances.
Yeah, it
that
was a
happened
very
there.
intense situation. So not only that, the emotional, right? The family wants to make decisions because it's their family member and he has been separated from this person. But ultimately, she was the one that was able to decide what offer she wanted, and the family had no say.
Well, they could have had say, but they would have had to go to court
Yeah,
and fight it because you'd have to look back at what was agreed upon 20 years ago,
right.
and then you can get a court order modifying that title. But it doesn't sound like they chose that path. But there might have been something they could have done.
Wow. So overall, it's better to be prepared
That's
and take
right.
care of these things.
That's right.
Yeah.
People, some people make the mistake of, I'm only going to get a lawyer if I really need to. But
Yeah,
sometimes you need a lawyer proactively to deal with situations before it becomes a crisis or before it becomes a problem.
exactly.
So estate planning is something that you can do proactively,
Yeah.
get it done, and a good estate planning attorney will be able to address, your particular circumstances, your family's circumstances, and also account for, future possibilities.
Right.
I'm dealing with a probate right now where a husband and wife passed away within 5 months of each other.
I've seen that before.
And my client, his aunt, they were blood related. She died first, and everything in her will, all of her separate property went to her husband. And then the husband's will says, first I want everything to go to my wife, but
Who's gone.
she's predeceased. And the will says, if my wife is predeceased, then I want everything to go to my brother. Well, the brother was also predeceased, so there was no beneficiary designated.
Wow.
So there are some probate code provisions that deal with the situation, but there's a fight on our hands because my client will inherit the separate property of his aunt. There's a code provision that covers that. But what's to be done with the separate property of the husband who passed away 5 months later? There are second cousins,
Right.
basically intestate heirs that he had no contact with for decades.
Right.
He basically moved out to California from the East Coast, and I think there was some sort of split in the family. We don't know exactly the history, but we're talking like 50 years ago. What's the story?
Yes.
So he was estranged from his family. I think in Rhode Island is where he was from originally. So there are groups called heir finders who are basically, they identify heirs at law
Yeah.
that can inherit, and then they send them a letter, say, hey, we'll get you your inheritance. You just give us 15%, and yeah, they're kind of like vultures, but they do serve a function. But in this situation, it's potentially going to result in something that the uncle of my client would not have wanted,
Yeah.
because there's a provision in there that says my heirs at law are disinherited, essentially.
Wow.
But that also includes the family members of the predeceased spouse. So
Wow.
we have this conundrum,
Yeah.
and we're gonna try and negotiate some sort of settlement in that situation.
As you mentioned that story or that situation that you have, that case, It reminds me of a situation in which I sold a condo in Santa Clara, and we were literally in the middle, and some family members showed up in Europe and said half of it belongs to me because this agency or a similar agency
The
found
air finders?
found that family member, and I was helping the cousin who was appointed by the court to sell the property. So he was so upset because the court found that he had to give that family member half of the money that he was going to make. And he said, this person never knew him. How do they even, I didn't even know we had family over there.
Okay,
So
so this is a situation where it's called intestate succession. Okay, intestate means without a will, because a will is a testamentary instrument. Okay, and so also a living trust is a testamentary instrument. So if you don't have a will or trust, your assets will pass on intestate. And so there's an actual California statute, the probate code, that has rules as to how assets will be divided up in that situation. And it's basically the policy that, the legislature actually has determined what, it's a presumption of what the decedent would have wanted. So first it goes to the children, then it goes to parents, if there are no children, and then it goes to siblings, and then it goes to first cousins and second cousins, and so there's a whole structure to how things are distributed, and that's what happened here. This decedent, they died without a will.
Yes.
And they would have been better off if they had a will, but even better than that is if they had a living trust.
Right.
Because a will still needs to be probated. In that situation, if they had a trust, they could have identified who they wanted the property to go to, the beneficiary, and probate court could have been avoided.
Yeah.
And that long-lost relative over in Europe wouldn't have inherited anything.
I've seen even situations where the mother whose daughter passed away, the father who had never met the child came about and said, "Oh, I'm the father."
That's right.
So the mother ended up not selling, so he wouldn't, the property, there was a loan on it, so it was going to be foreclosed on.
Okay.
And she said, "I'll let it go on foreclosure. We're not selling it." So he doesn't get any money.
Wow.
So
okay.
I'm not sure what happened with that, but she said, "We don't need your services because we're never going to sell his property," just so he doesn't get one penny.
Wow.
So
Sounds a little spiteful,
Yes.
but again, that's a situation that better planning may have.
Exactly.
But it was probably someone younger,
She was someone younger, the daughter, yeah.
Yeah, I know, people in their 20s, 30s, 40s, they're not thinking about a will.
Yeah.
Or a trust,
Right.
which is even better. But, you can actually quickly draft a will.
Yeah.
And without even witnesses, actually. But it has to be all in your own handwriting. It's what's
Okay.
called a holographic will. And because it's in your own handwriting,
Yeah.
the court can actually, or the petitioner trying to get the will, the handwriting admitted as a will, can use your handwriting to prove that it's your unique wishes.
Yeah.
So normally you need 2 witnesses for a will. It's a little different for a trust. Typically you have it notarized.
Yeah.
And the notary verifies your identity and so forth, and that recording is actually documented
Right.
in the notary's journal.
Yeah.
So there's a lot of evidence to show that it's been executed.
I think it's always best to have a trust. And another story, this recently just happened. Hopefully he's not watching, but there was this gentleman who visited my open house, and he has a property in Menlo Park that's worth over $3 million.
Wow.
And he doesn't have a trust. And he's the only one on title. So I recommended, of course, to create an estate plan and to reach out to an attorney. And his response was, do you have a feeling that I'm going to die soon? And I said, absolutely not. But that's oftentimes what I get. Why would I do that? I'm young. Although he seemed a little bit older, he felt as if that's just something that old people should be doing, not me.
Right.
So hopefully after our conversation, he was
Thought
able
about
to
it, yeah.
think about it. Yeah.
Yeah, I mean, some people, it's strange. Some people are superstitious about doing an estate plan.
Yeah.
And I had a probate that was a attorney in his 70s, I believe, who died owning roughly 8 properties around the Bay Area. So that was a very large estate.
Yes.
Typically estates aren't in the multiples of millions because people with those sorts of assets, they are smart enough to actually get a living trust done.
Yeah.
And so all of those properties had to be probated.
Right.
And it was very expensive. And everything went to his daughter. But had he just spent, or even done it himself as an attorney, he could have
I didn't know he was an attorney.
Yes.
Oh, wow.
Yeah.
Yeah.
But I think in that situation, he was superstitious and didn't want to deal with it. And I think that's what was going through the mind of your.
Yeah, that gentleman that stopped by.
That's right. That visited your open house.
And he also had gone through a divorce not too long ago and doesn't have children. So, I mean, I don't know the logistics. I just told him you should think about it.
Yeah.
Especially if your home is in that category.
So then everything would go to his parents, then his siblings, and and sometimes you don't necessarily want your assets to go to a sibling that you don't get along with, but you want it to go to your niece and nephew, or
right,
or a good friend that's been there for you.
Exactly.
So, yeah.
Yeah, it's something to think about. How often should an estate plan be reviewed? I think we talked a little bit about that.
I would say at minimum every 5 years.
Okay.
But if you have a major change in life circumstance, a new child, a death in the family, someone who gets really sick, or you get really sick, then yeah, you want to review it, and review it with an attorney. Is this really reflect what I want? And then you have a conversation about what you really want with your attorney, and he or she can verify that your documents reflect your wishes. And so at the minimum every 5 years.
Okay. And what do you recommend? I've had situations, in fact, even with my estate plan, where I didn't really want to tell my family about it, but I want them to know it does exist.
Yeah.
So what do you recommend when you don't want to have a full-on conversation, or maybe a parent feels bad because they selected one of the kids to be the trustee and not the other? How can they manage this conversation?
Well, I recommend that those conversations that they take place.
Yeah.
Because it can avoid problems down the road. You don't want your children fighting over your will or your trust in court. So if you have those conversations, I chose your sister over you to be the trustee of the trust because they're better with finances, or whatever reason it is. You have that conversation, but they're supposed to divide things up equally between you and themselves. If you have that conversation in advance, it can avoid a fight later, and resentment or what have you. But generally, as part of the estate planning process, you select powers of attorney, and you select successor trustee and executors. You should have conversations with those people that you're putting into those roles, so they, number one, agree to do it, and two, that they know that they're selected, and it's not a surprise later.
Yeah.
Yeah. Because
people do fight when someone's gone. I've had
that's true.
Situations where the sibling, or it's usually siblings, but we got along so well until my parent died, and I'm the trustee. Now they all hate me.
Right.
Yeah.
Yeah. Well, there's other things that can be done. Maybe a neutral third party, like an uncle or aunt who maybe is the trustee as opposed to one of the children, or even a professional fiduciary, although that's a lot more expensive.
Yeah.
So a professional fiduciary could be someone at a bank that has a trust department, or there's actually licensed professionals. Essentially they're called professional fiduciaries that can act in that role as trustee,
Right.
or power of attorney if someone's sick. I've seen powers of attorney hired, professional fiduciaries hired as powers of attorney when someone's very advanced in age and they can't really take care of their affairs, but they have the means to hire
Yeah.
that assistance.
Yeah, I think that's
There's
a great...
a lot of options, but
Yeah.
talking with an attorney about what your wishes are, what your concerns are, the family dynamics, a lot of that can be addressed within the estate planning process,
Right.
and even conversations about it with the people involved.
Exactly. And we also had Marina, who's a professional fiduciary in our channel before.
Oh,
So
great.
she's explained the process, but yeah, I've known that it's a lot more expensive.
Yes.
Yeah. But sometimes it is the
Sometimes
best
it's worth it.
option. Yeah. Yeah.
That's right.
Absolutely.
So, okay.
Thank you. Okay, so when we talk about probate, I want to talk a little bit about San Francisco since you are locally here. Do the prices, or I know people have to pay for the petition and different things for the court process. Does it vary depending on the county, or is it the same in California?
Yeah, the filing fees are the same
Okay.
in every county.
Okay.
The process is largely the same. Now, pretty much the courts allow remote appearance. So
Okay.
you can appear via Zoom in court. The courts actually like that rather than people shuffling into the courtroom every day. I used to do that pre-pandemic,
Right.
and it's much easier to appear via Zoom nowadays. So most courts allow for remote appearance. San Francisco is kind of unique because it's known as being sticklers for procedure and process, and there are actually some probate attorneys who will not probate in San Francisco because they find it too frustrating. It's a little more complicated. I actually think it's because the judges and the probate examiners, who are basically assistants to the judge, who review the paperwork and so forth, they're very good at what they do.
Yeah.
And if there's issues, they identify them, and you have to address them. And sometimes they have follow-up questions. So,
Yeah.
whereas maybe another county, let's say, for example, Lake County or Sacramento County, it's maybe a little easier to get through the process without so many questions,
Right.
and skepticism coming from the probate examiner about what you're trying to do. So, but San Francisco is the real estate is very valuable here. So, San Francisco Probate Court is quite active, and the probate cases are pretty substantial in value, as opposed to, let's say, Contra Costa County. It's still a Bay Area county, but it's going to be a little the probates are going to be less in value.
Yeah. I've actually worked plenty in San Joaquin County.
San Joaquin County, okay.
And I see a lot of people filing for probate on their own in that county.
Yes.
I would say, I don't know, like 30% of the people that I connect with.
Okay.
When here in San Francisco, it's very rare for someone to represent themselves in court.
Yeah.
Yeah.
Well, it's maybe a little easier to get through Ventura County, and people are trying to save money on attorney's fees because generally the way the attorney's fees work is, if it's a very straightforward matter, there's not any fighting over the assets or fighting over whether the will should be admitted to court or not. That's called the will contest. Straight up probate administration, the attorney's fees are 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and then it drops to 1% of the next 10 million. So, so it's kind of a graduated scale is what the attorney's fees are.
Right.
So with a larger estate, they can be quite exorbitant.
Yeah.
So that's why you want a living trust.
Absolutely. And speaking of fighting, which we've seen before in many probates and situations, can you tell us a little bit about how would you handle, or what recommendations do you have for someone who is going through probate and has to sell the property based off the circumstances and have tenants in San Francisco that are
Yes.
protected?
Sure.
Do you have any suggestions for us?
Well, each situation is a little bit different. If the tenants are, let's say, renting rooms, they may not have the full protections under the rent control ordinance here in San Francisco, or let's say the one over in Berkeley. They may not have all the full protections. They may not be able to stay on because the decedent lived in the house with them. Okay, it was kind of more like a roommate situation. That's a little bit different than if it's a rental property. If a rental property is in probate, you may be able to buy out the tenants, but you can't really terminate their tenant rights,
Right.
at least not easily, unless they're not paying the rent. And even there, the eviction courts are backlogged, and it's a messy situation, and you definitely need to work with an attorney
Yeah.
if you have a tenant situation, because you don't want to make a mistake and get into a wrongful eviction situation where you're being sued by
Right.
the tenant for violating their rights as a tenant. The tenant rights and protections are very strong in San Francisco, in Berkeley, and other rent control counties and cities. So definitely a landlord-tenant attorney is necessary.
Yeah.
It gets complicated.
Absolutely. I've seen it.
Yeah.
And what I always recommend, because people will say, I'm just going to take care of it on my own. In fact, I had one that said, I'm going to negotiate with the tenant, and it got so messy because if you say something or give them the wrong paperwork, you could be liable, right?
That's right.
So
That's
it's
right.
better to get an attorney to assist you. Although people think, but it's very expensive. It might save you a lot of money in the long run.
Yeah.
I think usually people are stuck on how much it cost initially.
Yeah, but that being proactive with an attorney in that situation can save you a lawsuit. It can also maybe get your tenant out quicker.
Yeah.
And so that if you're able to, let's say, negotiate a buyout of the tenant, then you can sell the property for more.
Yeah.
Because if I'm sure you experience this, if you're selling a property with a tenant in it, it's going to sell for less.
Absolutely.
Yeah.
Yeah. So I just thought about this right now as we're talking. Say that there's a tenant in properties that we worked on together, and for some reason we can't get the tenant out. Does the probate case move forward? Can it close with the tenant living there, or how does that, if there's other heirs and beneficiaries?
Well, the property can be sold with the tenant in the property. I've seen that many times. Sometimes you will have the heirs living in the property.
Yes.
And so I've been successful in getting a order for sale of real property, as well as an order to vacate, because
Okay.
they're not true tenants. They're really heirs in occupancy.
Okay.
It doesn't always work.
Right.
It just depends on the jurisdiction. I was successful in Alameda County with that, and we're trying to use that on a case right now in San Francisco County.
Okay.
The court's a little reluctant, but I think ultimately they're going to decide in our favor. At least I hope so.
Yeah.
So, that's another unique situation.
Yeah. So talk to an expert, because it can get very messy.
Right. I mean,
Yes.
most people don't fix their own cars, right? They go
Right.
to someone who knows how to do it efficiently,
Yeah.
and they have the right tools and the right facilities to do it
Right.
cleanly, efficiently, and so the law is very similar to that. And I would say when you're dealing with real property, substantial assets, attorneys can save you a lot of headaches, a lot of money actually, and a lot of grief. Yeah.
Something that I just thought about was don't use ChatGPT to guide you through the process. Someone who's been going through probate for the past 3 years, I spoke with her a couple weeks ago, and she said, "Oh, I think I finally have it because ChatGPT has been giving me the answers."
Oh my gosh.
And it
Well,
looks like she filed the wrong thing in court recently because ChatGPT told her, and she was upset because ChatGPT told her
Yeah.
how to go through probate. I'm like, I don't think you should be following ChatGPT on this. You should hire someone.
Yeah, that's basically ChatGPT is going to give you some general guidelines,
Yeah.
but it's not going to give you specific tailored advice for your case. Maybe someday it'll be that powerful, but there are actually attorneys who have used AI for research and so forth, and they've presented that research in their filings in court
Wow.
as their own, their
Yeah.
own writing or what have you. And they've actually been sanctioned by the court because they're
Wow.
not doing the work themselves, and it's just not an appropriate tool to use.
Yeah.
And yeah, you can learn things, but it's not a substitute for real legal advice.
Yeah.
You know, attorneys come with a lot of experience. They've handled cases like similar or exact same fact pattern, and they know how to deal with it, what strategy to use and what procedure to use.
Right.
You know, the probate code is several hundred pages long.
Yeah.
That's just on probate.
Exactly.
You know, landlord-tenant law, also very complicated. So,
She might be reaching out to you. I told her she needs to stop doing that.
okay, well, we're happy to help. And
Yes. So can you please tell us a little bit about how do you work with out-of-state heirs or people that are filing for probate that are out of state? Because I do get those type of clients often.
Sure, yeah. We've actually worked with people in other countries, and they actually cannot serve as the administrator of an estate, and so we have to find someone that can stand in the role of being administrator or executor. Because
If they're out of the country.
if they're out of the country,
Okay. Mm-hmm.
yeah, out of the country, out of state, someone can serve
Okay.
as the administrator
Okay.
or executor. That's not a problem, and because people can appear remotely, and we can handle so many things via email and courier, etc. Someone doesn't actually need to be in local to, let's say, where the real property is. You know, you can actually sell the property, and they can go to an escrow office in their local area to handle the transaction.
Got it.
And you know, but it is important to have an attorney in the jurisdiction where the probate's happening.
Yeah.
So if the decedent passed away in San Francisco County, it's going to be and resided in San Francisco, the venue is going to be in San Francisco.
Right.
So
Okay.
sometimes you'll have a situation where some of the assets are in different parts of the state or even in different states. And the probate court does not have jurisdiction over assets in another state. So
Okay.
let's say there's a property in Austin, Texas. Well, you're going to have to do what's called an ancillary probate and work with a probate attorney in Texas and follow all of their procedures. And their system is a little bit different.
Right.
California is very, it's one of the more complicated probate systems. It's probably similar to New York
Yeah.
as far as complication. But other states, let's say Nevada, I've had some ancillary probates there. It's a little more straightforward.
Got it.
So if there's out-of-state property, we would work with our clients to identify an attorney that can handle that.
Okay.
So I've dealt with needing to probate in Nevada, in Texas, in Hawaii, actually. And, that's part of it, coordinating a probate.
Right. And when the person doesn't live in the state, they live in a different state. Say someone lives in Arizona, they should or have to get a bond, correct?
Yeah.
Or does it depend?
Yeah, it depends.
Okay.
The court will require a minimum bond if there's an out-of-state administrator.
Okay.
And a bond in a probate bond is basically an insurance policy that protects the heirs in the event that the administrator, messes up the probate, or let's say doesn't have the property insured and it catches fire, or they run off with all the money to Europe or something.
Yeah.
So, but a bond can be waived by the heirs. So let's say the administrator is a very trusted person who's not going to, take the money or, be irresponsible, then a bond can be waived. And, for a larger estate, a bond can be quite expensive. It can be, a few thousand to up to $25,000.
Wow.
So, and that's an estate expense that gets paid out of the estate proceeds, but that's less money in the pockets of the heirs.
But that gets paid out at the end when probate has been finalized, right?
Well, or if the probate is liquid, meaning let's say there's a checking account that becomes part of the estate, then the expenses of the administration can happen before the final distribution order. So there's essentially there's a few different stages, but the two main petitions of a probate is opening the probate, petition for probate.
Yes.
And that could be with a will, of a lost will. If there is no will, it's a petition for letters of administration. So that's kind of the first opening stage. Then there's marshaling of assets, identifying creditors, paying off creditors, dealing with any disputes such as, the creditor claims or any lawsuits, doing tax returns, the last tax return for the decedent, appraising the assets, inventorying and appraising the assets. And then when all of that has been done, then the estate may be in a position to be finalized. And so that final petition is the petition for final distribution. Sometimes there's a full accounting that's done. What estate expenses were paid for, what assets were marshaled into the estate, all that's accounted for in an accounting. Yeah. Now, in a more simple probate, let's say there's only one heir or there's two heirs, the accounting, the formal court accounting can be waived. Okay. Let's say there's a basic accounting done and everyone's satisfied, everything looks in order. A waiver of accounting makes sense because it's going to simplify that the procedure for that final petition for distribution.
Who decides? Is it the court that decides if it's the simplified accounting, or it just depends on the assets?
Well, it really depends on if there's a small number of beneficiaries or heirs, then you can get everybody on the same page. Okay. And being very transparent. Here's what we spent money on. These are the assets of the estate. We're ready to distribute. Do you waive the accounting? Yes or no? If they don't, then you have to do what's called a formal accounting. And it's court approved, meaning the court reviews it to make sure everything's in order, that all the interest is accounted for on these accounts. And sometimes they can be quite lengthy, Absolutely. And you may even have to hire a outside person to do the accounting because it's in a particular format for the court, and some of it's counterintuitive. So
I actually went through. I'm a part of the State Planning Council in Santa Clara, and we had a judge that was speaking to us about this part of probate. Okay. And he was mentioning how judges do take their time to go through everything and make sure that everything's in alignment and is accurate. And in fact, there was a case in which an attorney charged additional fees and the judge sent it back because he wanted the attorney to explain those additional costs.
That's right. So so procedurally what happens is you file your petition. It's examined by the probate examiners. They're the assistants to the judge. They're usually attorneys and very experienced, very knowledgeable. They will identify issues. that they see in the petition. Such as in your example, there was not enough detail on these extraordinary attorney's fees that the attorney was seeking. So he probably had to file a supplemental declaration to explain exactly what he had spent his time on, and to justify it as extraordinary as opposed to ordinary probate administration that would be covered by that statutory fee that we discussed earlier, the 4%, 3%, 2%, 1%.
Yeah.
So, yeah.
There's a lot of moving parts for sure.
Oh, that's for sure.
Yeah. Okay, so as we're getting closer to the end, many people reach out to me because of the real estate part. A lot of people agents want to focus on probate and trust real estate, and oftentimes tell me, what are the 5 steps to be successful? And I cannot break them down because there's so many layers to this. You work with many agents. In fact, that's how we met. We were working together on some transactions. From your perspective and from your knowledge or experience, what is one common mistakes that agents make when they're working with you? Do you have any, just so we can help people out?
I have to think about this a bit. I'll rephrase my answer as, what are the good things that a experienced probate real estate broker does?
Yes.
They are problem solvers, because invariably there's problems that come up, maybe issues with title, maybe issues with repairs that need to be done. And so your real estate broker needs to have tools and resources to be able to help you. Let's say the estate is cash poor and doesn't have money to ready the property for sale. A good real estate broker will be able to either front some costs or arrange for financing to get the property fixed, really, so that it can pass an inspection to get a mortgage on it. Because otherwise, the property is going to be sold as a contractor special, as opposed to, a buyer that's able to get a conventional 30-year loan.
Right.
So your pool of buyers is a lot more limited if it needs to be, a lot of repairs need to be made.
Right.
So having a real estate broker that has the experience, has those tools, and, and who has your interests at heart.
Right.
Those are things that I would look out for. As far as common mistakes, I'm going to have to get back to you on that one.
That's okay. I'm glad that you haven't experienced much, because I work with some attorneys that can give me a list of common mistakes that realtors have made. So I'm glad you haven't experienced that yet.
Well, I didn't have any problems working with you, Mary.
Good. That's all we care about.
Yeah.
Okay, so as we finalize, what would be, again, because people often ask me, advice that you would give someone, a real estate agent, who is hoping to work with you or an attorney and just can't find the way to connect? Attorneys are so busy and sometimes have multiple agents reaching out to them. Do you have any advice for someone who's starting off who would like to work with you or another attorney in estate planning, since this is their niche?
Well, I get contacted by real estate brokers all the time.
Yeah.
And because as a probate attorney, they have opportunities to refer out a sale of a property. And so what I've always told people, or real estate brokers that contact me, you bring me some business, I will refer business back to you.
Right.
And that's kind of how you get in the door. And that's how you and I started working together.
Yeah.
And you brought me a really great probate, and it's been a real pleasure working with you, and I've since referred some business to you.
Yeah.
And I've gotten to know you, and I know that you really do care about your clients, and you do a really good job. So I've always respected that and appreciated that. So that's why I keep referring business to you, and and I appreciate the cases that you've referred my way too.
Yeah, thank you.
Yeah.
And just a short story, I think I might have told you, but when I started in this business, you're one of the attorneys that I wanted to work with. And it was during COVID. I remember knocking on the door, dropping off goodies, and you were not here, just like everyone else, right? People were at home.
Right.
But I was desperate, and a lot of the advice that I would get from other agents or brokers Just go to the attorneys and ask them for business. Just ask for business, give them your card. And when I connected with you, I realized, no, you have to also add value. I can't
That's
just
right.
ask someone to give me business. And that's what I tell people often, agents, you have to add value to this person's business as well. You can't just take, just as you're working with clients. You have to add value to their life. So after I changed my mindset and started doing that, my business completely changed.
That's great.
So I do appreciate you working with me and teaching me, because you've taught me so much. And we've handled some really crazy but amazing situations together, and things have gone through very smoothly and successfully. So I appreciate that.
Oh, you're
Thank
very
you.
welcome. And yeah, and I really appreciate some of the things that you've done apart from referrals, such as, doing a broker's opinion on a property or what the value would be. Yeah, so, and getting a preliminary title report. So, yeah.
Thank you. Where could people find you if they're looking for?
Well, my website is tswrobel.law. That's spelled TSWROBEL.LAW. That's my website. And then our phone number is 415-928-4161. And our email, info@tswrobel.law. That's a great way to contact us as well.
Perfect. And we're going to add that information at the bottom. Is there anything else you want to share?
No, that's great. That's it. Thank you for the opportunity to share information with your clients.
You're welcome. Thank you, Tom. I appreciate it.
You're welcome.
Thank you.